Corporations Act, right? 5 and 6 Statute 5 and 6 William. So we will notice that when they first brought in the Municipal Corporations Act, that almost everything was a strict function of government. It was only the citizens that chose to remove a bunch of those things and to bring them into a private jurisdiction. So you can already see that they're already moving things that were granted to them with only a use, and now they're granting it away to another jurisdiction that's a private jurisdiction, right? Because when we're talking about uses and trust, the donor grants to the monarchy creates a corporation, and then the donor, as a third party, volunteers for the corporation, right? So the monarchy is B, the government is C, and you as citizen is D. So you are now 4 degrees away from you as being the donor as A. So in trust law, as soon as you're beyond 3 degrees, you're now right? That's why it's called a third party interloper. And right, it's because now you have no privity to the contract that A made with B, right? Because you gave up the rights to it. You go and volunteer to a corporation that actually has nothing to do with the actual. It only has to do with the uses and trust, right? So you went and volunteered to a corporation that is basically a referee for all the people that want to live in the uses and trust jurisdiction where they're not living in their own right. So, right? Where you're going to be taken care of and everything else. So the problem comes in is by becoming the corporate person, because you're stating that now you're a third-party interloper and you volunteered. So this is where all this is actually coming down to, and where we need to get to, is because in the law of uses and trusts, as soon as you're the third party, you no longer have any say in what's going on in this contract. So that's why all the citizens that are trying to set off and get their life estate and true inheritance, they're actually breaking the law, because they're doing it as a third-party trustee who actually will never have any rights to that trust in your current capacity, right? Like they just played they played a game on us called ignorance, where they wrote a contract and nobody wanted to read it, and they just keep going and doing the acceptance part of the contract because they wrote it in a way that how everybody wants to live, that's just what they're going to make as acceptance of the contract.
I think it's important to highlight, because touching on those groups that you're mentioning that are trying to dispute the trust, etc., or trying to gain some monetary value out of it, they're not looking any further than their own government. They think the law starts there, so to speak. I also want you as well to just recap, if you can, from the conversation, because I think that the recording stopped when Andrew rejoined. So I just want to recap, if I can, ask you the question again: what is the land tenure, and is there a document for it? If you can just quickly summarise that.
Yeah. The land tenure is the actual live registration of birth that your parents signed and the director signed at the time of birth. That's the actual agreement to the land tenure, and the acceptance is basically using the birth certificate and signing for things as a trustee instead of in your true capacity. And because the parents actually signed an agreement for you, after 7 years, if it's not refuted properly within 7 years and brought within a court, it's got to go back to court again anyway to prove that you don't want the trust, right? So the land tenure is the actual agreement, and by us performing livery by cession, being seized of our lands and working for a corporate person, working as a corporate person, is accepting that land tenure, because the land tenure and acceptance are not on the same document.
Yeah. And what documents are they on? Bit of interference.
Does Andrew have a question?
No, I'm just listening. I've actually got the full set of documents from Pantera de Oro Society, Gemstone University. You've probably heard of it. So I'm just putting the two together from what you're saying and what I've got. If that makes sense.
Yeah, it sure does. If at any time, if you have a question or want to throw something in there, or we're all ears.
My main concern, William, is if you cancel, terminate the corporate person, what are you going to do? I mean, are you going to live in a cave? That's what I'm trying to get at,
Okay.
This is a common question. This is a common opinion that people have.
I'm not saying that that's correct. Some people have the means of supply of food, electricity off the grid. If you cancel the corporate person, terminate that, you've still got the ability to contract. However, you've only got you've got limitations at that capacity. Have you not?
Okay, that's awesome question. This is actually a really, really, really good question. Did we lose Justin?
No, I'm here.
Okay. So basically, what we have is what English law does is everybody that joins English law descends in title, so they go down. Everybody chooses to descend from their natural rights in English law. So what they've chosen to do is become the guardians of your natural rights and guardians of those in their natural capacity. I'm getting a really bad echo. So.
Are you still getting it?
Let's see. Nope, now it's gone. Can everybody still hear me?
Yep.
Okay. So where was I? So everybody descends in title. So they've chosen to put an agreement between them and their natural rights. So everybody in English law still has their they still have their natural rights, but they put in a whole bunch of agreements to supersede those natural rights. And this actually started back at the start of English law, in the Magna Cartas. The first set of Magna Cartas they pretty much ignored completely. Magna Carta 1225 is the actual first Magna Carta that they actually started to actually abide by. Chapter 4 of the Magna Carta 1225 and all the previous and all of them since state that everybody in fee simple are guardians to the land. So everybody that has chosen to be fee simple, we have to remember they only have a use of something, right? And they only have that use because of the monarchy. Well, the monarchy in English law has assumed the authority in law, even the way that they write it, that the monarchy owns the land. So everybody would then perceive that guardians to the donor would be that we're now guardians to the monarchy. But that's really not the case here, because that's the assumption taken for the trust law, right? Uses and trusts. So when we take it to the strictest sense, it's actually meaning us in our true capacity, because you got to remember, as soon as you grant that land tenure and give it acceptance, you are no longer a part of that agreement because you've chosen to be a third party to it. You see what I'm getting at? So in law there can only be one jurisdiction at one time. So if you agree to swear homage to one king, you can't go and swear homage to another king in another territory, right? You have to release that homage to your current king before you can go and give homage to another king, right? And that's basically what we're discussing here with the release part of it. So everybody assumes that they have true ownership of all these things when they actually don't. So everybody in English law, that's every judge, even the monarchy themselves, are inferior to anyone acting in their natural capacity as sui juris. That means that they have sworn, they have proclaimed, they have volunteered to be protectors of our natural rights and duties. So when we are no longer working for them as those guardians, we are now standing in our true capacity and can now claim our true inheritance that was granted at trust, right? Granted in trust at our birth for when we come of age or for when we have our age of enlightenment. You're going to notice that word is used actually quite a bit, age of enlightenment, because in English law you haven't actually grown up until you can actually wipe your own butt, right? Cut your own food and eat it. You kind of see what I'm getting at. If you can't keep yourself clean and maintain yourself, your parents aren't going to let you go and do your own thing, right? The exact same thing as we went and said, hey, we need somebody to look after these things for us, right? And until we can take care of it ourselves, right? This has just been for so long, it has now fallen for the assumption, and also why they keep making all these new jurisdictions that are just adding to the original. Like the Statute of Westminster II in 1255 is the first remedy for the theft of the lands by King William. Because we'll notice that the Domesday Book came out in like 1086, and that's the record of him stealing all the lands and everything attached to it. He documented everybody's cow, everybody's chickens, how many forks you had, how many chairs you had, how many tables, right? Right down to the nitty gritty, how many bottles of wine you have, right? He claimed everything attached to everybody's lands, right? And then they decided to come up with hereditaments, and hereditaments is all your liberties and rights that are attached to your lands. So they created hereditaments, which are your rights and your liberties, and then they attached that to your lands. So when we give a land tenure, we're granting everything. So the assumption by people thinking that as soon as we give up the corporate person, we don't have anything, which that's true, because when you give up your corporate person, you've only terminated the personal jurisdiction. The land tenure is still in the hands of the Queen, right? Because the government doesn't hold the land tenure; they only hold the corporate person. So that's why we only have to deal with the government. We're dealing with the corporate person, nothing else, because they don't have any rights to anything else whatsoever. The only contract we have with them is being the corporate person. Everything else has to do with the monarchy holds the trust.
Which is why you've obviously, at the same time as you releasing, you've got to put your claim in for your lands at the same time so that you can get your own jurisdiction, so that you're part of our group, because you have to have a jurisdiction, don't you?
That's right. Law of domicile is everybody's born on a piece of land, and somebody has to own that land, right? Because English law, all land is owned. If it's actually not owned by an individual, they assumed ownership of it, so they could manage, right? So they can be referee of it. Who has the proper capacity in law, right? Who can come and actually claim it, and who actually has to come buy it, right? Because there's a difference. Like, that's the test in law, is if you actually purchase the land, you're in fee simple and you only have a use. If you actually did not purchase that land, you are a sui juris and you are true ownership, and you have true ownership of that land. So getting back to the about if you give up your corporate person, you're kind of screwed. Yes, but only at that very beginning stage, because now as soon as you give up your corporate person, you've moved to what's called remainder.
Man.
That's right. In English law, there's only 3 types of titles. There's in possession, there's in remainder, and there's in reversion. And those are the only 3 things that English law has jurisdiction over. Possession is you've accepted being seized of lands and working the corporate person. Remainder is you're no longer a corporate person, but you're still seized of lands. Reversion is you're not a corporate person and you're vesting. In other words, you're taking back your land trust. Once you've completed your reversion, you're no longer in any English law jurisdiction, and you create your own common law of the land. So, if we take this even farther, everybody in fee simple are guardians. They don't own anything, so they actually need a permit or a license to cut a tree, to dig the ground, to put in a septic field, everything. So that means all the cars, everything everybody's driving, all the roads they're driving on, everything that they're using to eat with, including the animals, are all a waste, because they are not allowed to touch them, because they don't own it. They only have a use for a fee. So that's why when you need to go and get a hunting permit, that's why you need to get all these things. You can't dig the ground, right? And if they don't want you having a garden on your front boulevard, you can't have it, and so on and so forth, because they've assumed the authority over managing the waste of the trust. So everybody has to register everything that they do. There's a permit for it. You have to pay for it. There's accounting for it, because they're accounting for the waste, because this is an equitable jurisdiction. So all they can do is accounting, right? So everything that, right, and that's why the individual also has to declare all their income, and that's why you can only do so much in cash before you got to start declaring it, because even the cash is purchase, and purchase is under a license. So you're using that money under a license because you've granted your lands away. Once you have lands in your own true natural capacity, anything that anybody is holding in fee simple, if you want it, all you have to do is write them a writ of waste, give them a notice. If they don't, actually, you write them a notice. If they do not comply with it, you go to their jurisdiction, their court of their provincial, the jurisdiction that deals with that matter. So if we look at the British North American Act, we notice that only the provinces deal with the actual property and the equitable value created from it. So everybody going to their federal governments and attorney generals of their country are in the wrong jurisdiction. They are going after the equity, and they are being vexatious because equity judges can't hear or determine common law. Only a queen's judge or a king's judge can determine the contract between the king and the donor, or the queen and the donor. So when we actually are in that everybody has one and everybody has a capacity in it, anytime that we actually try to claim something from somebody or anything else, we have to show 2 things. We have to show that there's a law that gives us the authority to do it for ourselves, right? And there also has to be a law for that person that we're trying to do it to, right? Because if there was no law, there is no acceptance, and then we're going to run into a problem that, hey, you can't do that to me, and what gives you that authority? Right? There's a thing called freedom that happened in the Bill of Rights 1688, and now everybody's free and chooses to do these things out of their own choice. So as we can see, the fee simple actually don't own anything, and when we're standing in our true proper capacity as sui juris, when we require something that they're wasting, because the waste is them giving it away, because a sedekey trust is you granting a trust to another for no benefit of yourself until it's terminated. You cannot set off against it. You can't do anything to it, right? Because nobody can until it's terminated. Now, a trustee is a different situation because they assumed ownership of it, and and in any trust, it's like if you wanted me to take care of your property and rent it up, let's say just take care of your property, and it's just going to be vacant. Well, and I'm to take what we agreed upon in fees out every month. Well, if I don't make that property perform, and after so much time, that property is going to be mine, isn't it? Because if I don't make that property perform, but yet that property is going to pay me each month, and that property isn't bringing in any income to pay me, aren't you actually giving me that property to take care of it? Because I'm just going to eat it all away to nothing in my fees. So that's why in trust law, when somebody gives something to another, they have to take care of it, they have to make it perform, they have to do certain things. So that's why there's also, like, if you look at the Canadian Ownership Determination Act, there's already a set rate for everybody that's a part of the group, so they get a certain percentage of all the natural resources that come in, right? And it's 12.8%. So, and then it also works out what they get paid, and so on and so forth. But now we have two trustees. So we have the government that are acting as trustees that has been granted by the monarchy, and then now the monarchy is being paid under that same trust as well. So when we actually step back and take a real good look at this payment system and taxation system, they have to tax everybody on the lands. They have to increase this income. Otherwise, the government will have nothing to give their services, because they can't even take the trust until so many years after the natural death of each individual. Right? I think it's 25 years after, like, if my father died today, I could actually go and get, because I'm the next one in line to my father. If he chose not to close his trust by the time his natural death, I have 25 years after his natural death to claim his true inheritance as my own. And that also falls within the remainder. So when you're reading in remainders and reversions, it also talks about that. So that part of remainders is going to mix people up, because they keep talking about A and B and C and D and this and that and blah, 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 and gives it to this and to that person, blah, blah. And that's basically what they're getting at. They're basically getting at is everybody has their own natural trust. And it also applies that if he doesn't cancel it, I have the right to do it, because I'm in natural law, I'm the next one that, right? I'm the next descendant in that title.
Does that only count for when they pass away? So
that's right.
Yeah.
That's right, because it's their own choice, right? I can't force you to get out of the system.
Yeah.
Right? I can't force you to do these things that you don't want to do. So that's where that all boils down to. So getting back to not being able to have anything or anything like that, it's not made so that we just go into reversion and go in and sit on a tiny piece of land and then force all the fee simple to do things for us. That's not how this system is based on. People have to start looking at it like this current since this set. I think I'm going to jump to something here. It's basically on the exact same lines, but there's an important part of history that everybody keeps missing. From 1066 to 1600s, English law was a complete tyranny and slavery. They brought in the equity, because you got to remember the foundation to the system from 1066 to 1600s. All the law that these people are bound by says that they cannot injure their subjects. They cannot destroy the system. All these same things that we hear today, right? You can't attack somebody else's system. You can't take something else from somebody else that they want if they want it, right? It's kind of the freedom, the catch-22 thing to freedom. So English law was a complete tyranny into the 1600s, so they created equity to give it to the people. So if the people actually decided, they could take the equitable jurisdiction and teach people the truth, and give a way out for if they chose. So municipal jurisdiction that we're in is a temporary system. Right, 1688, and we've had a choice since then, and
Just
we've
repeat that
allowed the
last,
city of London for
the last two sentences, because I think you cut out a bit there.
In the Bill of Rights 1688 released us and gave us our freedom, and no one has chosen to take it since then. We've all chosen just to ignore that and volunteer to the corporation. We got a new joiner.
Nice.
Hey Kev.
Hi, right everyone. Sorry I'm a bit late.
How are you, mate?
No worries.
That's not too bad.
We kind of been talking about the release and the history and law and jurisdiction.
I was up to what you were saying there, and I'm on point there. Like, no one's took it, and we've been forced as a corporation now. Yeah, I agree with that in total.
It's kind of forced, but it's only we're kind of forcing ourselves because it is written, and that's kind of what I was actually kind of getting into right now is, like from 1066 to 1600s, it was a complete tyranny. Everybody was forced into the system, and it seems like that in order to fix all these problems that have happened since 1066 to 1600s, they created an equitable jurisdiction so the people can actually take control of the law. And if the people that were in control of the law since the monarchy granted the parliament to the people in 1600s, we would have a different system here today. But the underlining part of this is the livery companies, because the livery companies started, they were actually started before King William and far before King William, and even before, I guess, the birth of Christ. But you know what I mean? Like the date that they said that it's 000, right? And then before Christ and after Christ, right? I'm kind of just dealing with the dates that they're using in English law. But the biggest fact is that in 1600s, everybody got their freedom, and nobody's taken it. And these livery companies, right? Because acceptance is livery by cession, right? Working as a corporate, right? Working for the guilds and being seized of lands, right? So when we actually go start looking at English law from the very beginning to today, livery companies and our corporate person, it's really going to start making sense to people, and that this is just a temporary system, and that as soon as we go from having a title in of possession in fee simple and go all the way to claiming our lands back in reversion, once we're out of English law, everybody that is in English law would be the guardians to you as the natural individual being sui juris, right? And the one of the previous question was, well, because what would we do if we gave up the corporate person? Well, if we give up just the corporate person, then we're in remainder, and we're kind of stuck because they still have the land contract. So once we break the land contract, that's when we're standing in our true natural capacity, and that's when everybody that's in fee simple are basically unlawfully using everything that they have, and it would actually be yours, right? But because the English law equitable jurisdiction of fee simple, I believe, is set up as a temporary system. It's right. Not made for us when we get into reverse to sit, like to go grab like a 10 acre piece of land where we can't grow our own food, right? You kind of see they're getting where we still have to depend on the fee simple, right? The fee simple, everything they do is unlawful. So when we actually realize that it is unlawful and it's destroying our inheritance and their own inheritance as well, and it's killing our planet, because it's the laws of equity are completely opposite. It's like yin and yang of laws of nature, right? It's the complete opposite, and everybody's really started to put that together with everything that they've created since then. They're showing like, no, this is backwards, right? Like everything, right? Like how we're growing foods, and basically everything is completely backwards. Medicine, everything. So when we actually start realizing that all this stuff is unlawful, and we should only be going after the things that we absolutely need to benefit the donor society, right? Because everybody acting as sui juris that takes their lands back in their true capacity and have true ownership, they're also in a society of their own, right? Even though we don't have to agree now because we're talking about the laws of nature, right? But we're all still in the same capacity, bound by the same laws. That means if I go run off that cliff, guess what, right? The laws of nature says I'm going to fall down that cliff and I'm going to split my head open, right? You kind of see what I'm getting at? So, and same with the laws of nature, saying that if we can't grow our own food, well, what happens when the fee simple screw up all what's left of the food and all what's left of the animals? Then what are we going to do? You kind of see what I'm getting at? So,
yeah.
Yes, we can take whatever we want from the fee simple, but it's not made for that we can just
take.
Yeah, and not fix anything, right?
Yeah.
Like we're to take from them to create something better, to show all those people in fee simple, hey, there's something better out there, and there's different ways to do things, and you don't have to be forced to do them in that backwards manner. Right, because as soon as you join the group, you're forced now. You can't go and hunt for food if you can't afford it.
When equity came in and the corporation came in, though, I felt it was attached to everyone to give everyone the rights at that time, because as you said, the law was going nuts, and there was there was feudal law going on. People were just pulling guns on each other and having a duel and shooting each other, and that's when equity came in. Because if as a family back then, if you'd backed all your money onto like your brainiest son, and then your brainiest son got into a duel, and that was what your family's attachments were to, then really speaking, you just lost everything.
Exactly.
So what they'd done was they give everyone the corp title, so to attach your rights to at that time. Now, as you said, it was an offer, and at that time it probably made good sense, because that was you getting protection.
Exactly, but
the protection's going to be far now. The fee simple isn't that simple anymore, is it? As it's put, and the codes and the way they're making the money to run the system, i.e. taking a bill into Parliament and then putting the charge onto the people to make the money for the system to keep it going. It's gone too far for itself. It's a perpetual system, and it's only the system's the winner.
Exactly, yeah. And to be honest, truth, the way the current system's set up, I'd rather go back to the laws of the common law, where I have the choice of doing the duel.
Yeah.
Because, right?
No shit. At least it's fair.
At least you have a chance, right?
Yeah.
Fee simple in court, not understanding these jurisdictions or the agreement or anything else. We don't have any leg to stand on. So it would be better for us to say, okay, let's just go outside and swing some swords, right? You'd have a better chance of winning in court without fully understanding the system to go in and do a battle.
Listen, I've been in court that many times and dragged through that shitty system that I would love to just say to that judge, listen, get outside and put your dukes up, mate. Me and you now. There's nothing I'd love more than rolling my sleeves up and cracking one of them square in the nose, mate. Oh, leave your wig on so I can just clean your blood up with it. Oh, I hate them. They're so far off themselves. But it goes back further than that, as you said. Sumerians is the first text of it, really, isn't it, that we've got at the moment to look to. And from then on, really, it's like the class of the elite, isn't it? It's like them giving the illusion that there is an elite. So as we do think, yeah, well, they deserve to be, having more than... No. That was just that to slow your roll. I think that's a bit played out now, and I think we're as a whole, as a unit, the whole Earth, we've moved on a little bit since then. So it doesn't make sense that we all praise, Queenie. No one thinks that way no more. As William said, there's no one being elected because it was usurped by William.
That's
Since
right.
so no one's actually got anything in play. We're led to believe, but you're led to believe because you've been we have a system now where if you don't take your kids to school, you get fined and you start coming down. So you're indoctrinated into this system to believe that it's right from a very, very early age. So they're giving the words that into our mouths that we use that is entrapping us into this fucking system of perpetual debt.
Yeah.
And not being able to own anything, and even if you do well, you're doing well for the crown, not yourself. It's never your work because you're locked into this corporation.
Well,
So
that's what we're trying to show people here now, is that we're actually not locked into the system. We're only locked in the system because we have an issue. We have an issue that the contract and the acceptance are two different things. The acceptance is is livery by session, so that's why the judge always asks two questions. Right, as soon as people are like, all the recordings and everything else, and all the court hearings that I've had, which is hundreds of them, the judge, whenever anybody challenges jurisdiction, he asks two questions: what do you do for a living, and where do you live? That's all he needs, because that's the acceptance to the contract. And when we actually start understanding the contract and what the acceptance is, all this falls apart. Just like this equitable jurisdiction, everybody that's in English law is in fee simple, and they only have a use. So when we look at the whole picture properly, as soon as they lose the acceptance, they don't have anything anymore, because you kind of see what I'm getting at. So as soon as you remove that
else.
That's right. So, because freedom was granted in the Bill of Rights, 1688, right? So now we have to consent.
We're only bound by our own actions.
That are exactly actions, not words.
Right. Yeah.
Actions,
and the actions. But
right?
my thing with it is, we've been led to believe, growing up in the society, that these are the things you do.
Exactly.
So
and
that's where it's wrong now, isn't it? We should have been given the opportunity to know the other side, at least.
Well, that's what I was saying, because you got to remember, since 1600s, the people have been granted the right to make the laws. The monarchy just has to agree to whether or not if they comply to the common law or not. See what I'm getting at? So as long as it's written to comply with the common law, she's going to accept it. So it has nothing to do with the monarchy. It has to do with us. We actually let them do these things for so freaking long by us ignoring the law, because no one has ever looked at it. All the scholars, if people actually read the introduction and preamble to most of the law books that are on omnipotence,
would that not be what am I trying to say? An abuse of trust in the position of fiduciary, which is what they're in.
No, they're not. Because you got to remember, we're all in fee simple. Because you, as the donor, grant a land tenure to the monarchy. The monarchy created the government and gave it its powers.
Yeah.
We then go and volunteer to a corporation and work for a corporation. We're not working for the monarchy. We're working for the corporation for the things that they give us, and we volunteered to them. So there is no there is no the government doesn't have to do anything for you because you went and volunteered. You said, okay, yes, I'm gonna accept that agreement that you're giving, and I'm gonna accept it, and I'm gonna do it as it states, right? So we actually have screwed ourselves because in trust law, right, and everybody keeps saying this all over the internet, third-party interloper. Well, that means you're past 3 degrees away from the original contract. I've
read this.
Right. So you as the donor grants to B, the donee, which is the monarchy.
As soon as you're in D, you're fucked.
Right. Creates the corporation and gives it only the rights of use, which is C. Right. And then you now are D. Right. And volunteer to the corporation. So you're actually the usufruct. You're the sette-qui-vie, and you're the third-party interloper when it comes to the donor. So all these people that are going into a corporate court as the fee simple, that they haven't gotten their deed of release from the corporation saying they're no longer that D, right? Because if you're not D, you're A, right? Nice. You only have 2 choices, right? A or D, right? You can't be B and you can't be C. You kind of see where I'm going at with this? So by you standing in front of the judge without a deed of release, he has no way but to say you have a contract. And I can't do that for you because you're acting as trustee and you don't own that thing. So how can I give you that thing that you don't own? Right?
Exactly.
And this goes back to the law and jurisdictions. Law and jurisdiction, same with that thing. So the judge is in a jurisdiction of his own where he can only do the things that you tell him if you show him the law that shows that he can actually do it. You see what I'm getting at?
Yeah, you have to leave them.
So if you're trying to, that's right. So you have to show that you have the law that proves that you have the right to do it for yourself. You have to have the law that shows that you have the right to do it, that you're doing it that you can do it to that other person, right? And then you have to show the judge that he has to do it because of those 2 things. You see what I'm getting at? So when people actually start and this is called finding the seat in law, right? Finding out what capacity each individual is and what laws they're bound by. Because we can even go into this a little bit deeper, where a citizen has different rights in the group than a cop, than a police officer, and also he has different rights than the attorney general. And then he also had all these, right? And then there's also, then a judge has different, right? A judge is bound by different rules, right? So each one of those individuals within that group are all within a different jurisdiction and all bound by different laws and agreements, right? And then if we look at judges even closer, if a judge is in a corporate, in a corporate court of equity, that is provincial or federal charges from government created law,
county and magistrates for us.
That's right. That's a court of equity. They can only hear and see claims of equity. So if you're going to try to bring in a claim as the donor in common law into that court of equity, he can't hear it. You have to do a certain process for him to hear it. And he can't even hear it. He has to move it to the Queen's bench because he has no jurisdiction to hear it. But yet, there's a certain process he has to follow. So if an individual brings this to him in this manner, he has to transfer it to this other person that has to deal with it. You see what I'm getting at? So we're all going into the wrong court in the wrong capacity with the wrong motion. And that's where when a judge says double split, right there, that should be a fireworks going off that you're in the wrong capacity and in the wrong jurisdiction. You're wrong on 2 levels. So that's why these equitable courts are always saying double split, sovereign citizen, free man on the land. Because let's face it, now that we understand what tenures are and what free man is defined as in the municipal corporation, right? Did you see that post that I made on definitions and what they mean in the capacity of the person, right? A free man in like 1066 was somebody that was not a subject and was free. By the time it went into the Municipal Corporations Act in the 1800s, free man now means that you've accepted to be a part of the group, right? And you're still a free man, but you're still bound by the group's laws and agreements. So everybody that's going into the court and saying that they're a free man, the judge is looking at them as, okay, you're in fee simple because you haven't handed me a deed of release. So all the words that you're saying that are coming out of your mouth are all within the jurisdiction of the fee simple, right? So if he was to define these words and saying, I am not in fee simple, I'm using this word in this capacity, in this jurisdiction, it changes everything. Do you see what I'm getting at? That's how we move the courts, because the jurisdiction is based on you, not on somebody else. It's what your actions are and what your... When you go into that provincial or federal court and he asks you, okay, I'm challenging personal jurisdiction and subject matter jurisdiction. Okay, Mr. Ruiz, where do you live and what do you do for a living, right? And now if you say, well, I work for Walmart and I live at 555 Centennial Street in Winnipeg, then, well, hey, guess what? You've now just granted library by session, and you've now granted the judge authority to assume that you're the corporate person, and now he will attorn for you because you've already agreed to be a part of the group, and as soon as you agree to be a part of the group, you've agreed to all the laws of that group, right? It's like joining Costco. Right? If you don't want to be a Costco member, and you don't like the rules of Costco, you don't go join Costco, right? So that's basically where this is all going, is that people are just being in the wrong capacity, in the wrong law, in the wrong jurisdiction, and trying to do things that you can't do in that capacity, right? Because let's take it even farther. If I give you a car, and I say, okay, you can use this car, and I want it back in the future when I ask for it, and if you sell it to anybody else, they have to give it back to me too. Okay? So I sell you the car, and I come back, and now you don't want to give me the car back. Well, you have to give me the car back, for one, because it's my car, and you already agreed to it. So if I take that to the judge, he's going to just force you to give me the car. Right? And then same thing is if you sold that car to somebody else, because I gave it to you, that you had to transfer that use to the next person. That person now takes on your duties as that trustee and bound by that same agreement. Now, if you didn't give them notice of it, right, then we kind of get into a little bit trickier of a situation. But if you did give notice of it, right, then you're bound by it automatically, and you'll also have to attorn to it. So if I come back and I gave it to Jerry, and Jerry sold it to Paul, and now I come back and he's like, Paul, I want my stuff. He's like, no, I take it to court. The judge is just going to attorn for you, right? We're going to put in the claim, state the facts. You're going to reply to it, and then I'm going to send in my affidavit proving the facts, right? And also I'm going to give a notice to admit. I'm going to notice to admit the actual contract. So you have to agree or deny it, right? And there you go. You have to agree that you saw the contract and that you agreed to it, and now that's the law. And now that's proof for summary judgment because it's all fact of law, right? Because I noticed to admit the contract, and he agreed that yes, that he signed that contract. So now he's bound by it, right? And that's why if we look at all these registrations and everything else in fee simple, they're all deed pools. You're signing them as a trustee. You're not acting in your own right. And that's why your live record of birth, the long form, it's actually an indenture because you didn't sign it. And you did it before you were of age, so it has to be an indenture. Because law of conveyancing and law of uses and trust states that that's exactly what that is, because it can't be anything else, because you have to sign it in order for it to be a deed pool. Otherwise, it's a bond in your name, right? Means that that's your remittance. That is your contract, the subject matter jurisdiction to the land tenure. So when you take that into a proper court of jurisdiction in the proper capacity with the proper claim, it will, and you will get you'll get your remittance, because that's what's required in a contract, right? All those things have to be done to get something back, to create a contract, to break a contract, right? There's a basic fundamental to it, but that fundamentals change as soon as you join a group. Then that group can change how those fundamentals work, right? So now that you're in English law, there's consumer protection acts and everything else, all these things to make sure that the ignorant people just won't keep signing contracts without reading them, and right, because we've had these issues with cell phone companies and everything else that just go and make ridiculous laws, and people don't do anything about it. So then the parliament actually has to say, okay, now we have to make an act, because nobody's actually coming forward, taking this to court and restricting them themselves, right? It's all because we run from the courts, when the courts are only for us. The courts are not for the government. The corporate courts are. The Queen and King's courts are only for the people. That's where we go for remedy, and that's what restricts the courts, and that's the only jurisdiction we can stand in common law. How is that spiel?
It's all on the edge.
Good.
Anybody can jump in and cut me off at any time, eh? Because I get...
One thing I did want to say as well, one of the other questions obviously you asked me at the beginning was when we were obviously producing our claim or trying to get our claim together, how many levels or jurisdictions are there that we have to dispute or remove? Is it just three?
Possession, remainder, and reversion. There's only 3 titles to English law, so there's only 3 capacities. Those are the 3 main jurisdictions, because everybody else within those either only have a use, right, or you're the donor.
So you only have to deal with the one in equity then?
That's the main part, yes, is dealing with the corporate person, because if you're the corporate person, you can't deal with anything because you're bound by the laws and agreements of that corporate person. You're basically a machine. Mm-hmm. Right? So as soon as you're in remainder, now you can vest your land now you can vest your true life estate. And now you can get your equitable interest in everything to it. Right? Because removing the possession is removing the acceptance. Remainder and reversion are the next steps to getting out of the system. Remember, we came into the swamp, right? So reversion is us coming in. We granted the land, right? The land tenure. So now we're in remainder. As soon as we grant the acceptance, we're now in possession, right? So now we have to reverse that. We're assumed as being in possession by being the corporate person, because that's the only thing that gives possession its acceptance, right? And then once we've removed that, now we're standing in remainder, because now we have another contingency that we have to perform, right? And that's to vest the land tenure. So once we vest the land tenure, now we've terminated the subject matter, right? The possession is the personal jurisdiction. The land tenure is the subject matter jurisdiction. So that's why the reversion is between the acceptance. I mean, that's why the remainder is between the possession and the reversion, right? Because when you're in possession, there's a remainder left over, right? Because there's the one estate is right. We grant one estate to the monarchy, and the monarchy can't give true ownership. So they have to make 2 estates out of the one and grant everybody just a use. So she always retains that true ownership that's annexed in law in the fee simple absolute, right? Simple absolute is the warranty annexed in common law to get our true inheritance back. The fee is stating that we've been seized of it, and we now have to pay a fee. Right? Because you have a use for a fee.
And the simple is the warranties annexed in law.
simple absolute. The absolute conveys an absolute warranty in law.
Yeah.
Have you? I know Justin has seen it. Has Andrew and Kev seen that from Blackstone Commentaries? Him actually stating the warranties annexed in common law.
I have read it, but it's not jumping out to me, so I will make another point of reading over it.
It's in
Here, I'll put it.
Blackstone 2 commentaries 106 and 201, I think, in Rice. Page 106.
I just posted it. I just pasted it in the room as well. A screenshot from it.
Cheers.
So we can. I'm sorry. What's that, Andrew?
Can you hear me?
I can hear you. Yeah.
Yeah.
I've had a brief look at that. I did have a question about the reversion. How does the reversionary interest get back to the fee simple absolute?
Okay, now we got to remember we have two jurisdictions now, as you being the donor, because you have the land tenure, and then you have the equity attached to it. That's the fee that the trustee has to pay to the beneficiary's trust for having the use of it. So we have the land tenure, which is the lands that you claim, and then we have what's called the waste, which is all the equitable things that they did to it, all the trees that they cut, all the grounds that they dug, the homes that they built, any fencing that they put up. It's all a waste in law to the donor that they claim a part of the reversion process in a writ of waste. And that's also what
how does that actually come back to Jury? How would it come back to us as living free man on the land? How would we actually get that? How would it present ourselves, seeing as we've rescinded and revoked all the presumption, we've issued a release of the deed of release, etc., etc. So how would we, in what form would it present itself back to us, the estate?
Yeah, very good question. We're still getting quite a bit of feedback from your mic, Andrew.
Okay. None better?
That's better. Okay, so basically we have to remember that you can do each one of these processes separately, or they can be done all together. You can, because starting at the release of the corporate person, as soon as you give notice to the company that you no longer want to work for that company, they have to come to an agreement on when your last day of work is. If they're not willing to release you from your duties, that's an injury. So you got to remember, as soon as you've proved that you're no longer the corporate person and that you've returned from sea, I'm hoping.
Hold on.
So as soon
as crisps.
So I'm hoping you guys are familiar with 6.and chapter 18. That's the affidavit for returning from sea. So you got to remember that the acceptance part is the acceptance in being the corporate person is the only thing stopping you from being able to use these writs and everything else that are only for the donor. Right? This is that capacity and jurisdiction that we have to always keep at the very front of our mind at everything that we're doing, because it means everything in law. So as soon as you're not that corporate person, you're the donor, because you can't be the monarchy and you can't be the Corporation of Canada, let's say, right? So you can only be a citizen or a donor. Right? You kind of see what I'm getting at? So in order to get to the equitable, in order to get to the waste and to get the equity attached, you have to terminate the estate, and that's the land tenure. So as soon as so that's why I'll just quickly throw it out here really fast what the procedure is. And from front to back, the very first thing is you have to get a deed of release and return from sea. That gives you the privity of estate to make a claim of right for lands in your donor to take lands from the individual, not buy them.
That gives you the privity of the estate to...
By having a deed of release from the and releasing you as the corporate person gives you the privity in law to now vest and terminate the land tenure and life estate. So the only thing stopping you from writing a writ of entry to decision in the post or any of these or any of the other common law writs for the donor is you being the corporate person. So the only thing that the judge can actually use to say that you're being vexatious or frivolous or a double split or that's gobbledygook is because you're still standing in front of him as the corporate person. As soon as you have that deed of release, everything else is basically they're forced to do it because you're standing there as a donor. And as I said earlier, all the judges have to be fee simple first. So the judge, when you're standing there as donor, the judge is standing there as the trustee.
Yeah.
So it's his job to give it back, and not only to give it back, but to protect all your rights. So now, if the government, if the government's been doing shady things, and you have a claim against the government, and it's all in one shot, with you claiming the lands, then the government's in a real big pickle, because as soon as you have the lands, as soon as you've claimed the lands and you've gotten the judge to make the determination on the lands, now your writ of waste applies. See, so in your claim, you can have your release of corporate duties, your return from sea by 6.N Chapter 18. Then you're going to have your writ of entry to claim your lands, and then you're going to have a writ of waste right after it. And you're going to have all that. You can have all this right in one claim to have it done in one shot. Right? So it can be one claim with 4 levels.
Yeah. Right?
Because you're going to deal with each one at a time. Right? In that order. Because you have to make sure that you're out of equity, because CSEE and CSEA is both equity. That's you being in an equitable jurisdiction. It actually deals with that in the Bill of Rights 1688 as well. And even in the Bill of Rights 1688 it says anybody that's in the C jurisdiction is barred from their trust, right? Which gives you more proof that when you're gone to C, you're a corporate person and you're not acting as A, but you're acting as A, B, C, D, right?
Yeah, 3 degrees away.
Yeah, so
cut your head off.
So when we go into the foundation of this stuff and we get to the nitty gritty of it, which they don't want to, and that's what another reason why they created equity, is because you go into a new jurisdiction, and everything in the new jurisdiction that you go to assumes all the past laws and everything else previous. You see what I'm getting at? So in order for us to really trace the truth to English law, we actually have to start in 1066 and work till today, because a law that's created today starts today and works forward. It doesn't say where it got its authority from, so we can't work backwards from today to 1066 because the law doesn't give us any information to trace it. But if we start from 1066 today, we can find it goes from one to the other, to the next, to the next, to the next, to the next, and it's one big chain. There's no break in the chain. If there's a break in the chain, there is no jurisdiction and there is no force or effect to that law that they created. So everybody today is basically just looking at law after the 1900s, pretty much after 1985, to be honest, when all that's already assumed and it's a completely different jurisdiction than the other one. And no one can find out whether or not it actually has true force or effect because they can't find the originating monarchy common law that gave it effect, because the monarchy creates all laws. So there has to be a monarchy statute to give it effect. Because the fee simple can only create the laws that the monarchy gives them authority to create. Right? So that's why it's important to realize jurisdictions and the UN and private international law of agency, right? And these sort of things and the history to them, and putting it all in a chronological form, right? It's best to start a file folder in your brain all with dates, right? Not with the law itself, but with dates. Because when you put it with dates, it's all going to really start to come into play as soon as they did something on this date, and then boom, then all of a sudden there's a whole new jurisdiction created afterwards. And the citizens of these corporations, like let's look at it this way, if Canadian Tire and Walmart
probably looks like a bad search, but I didn't actually
I see.
If Canadian Tire and Walmart were to amalgamate together, would the employees of Canadian Tire and Walmart actually have any idea unless the actual owners told them? Right? Kind of see what I'm getting at?
Yeah.
So that's basically the exact same thing that's happening here, because these are all corporations. The people don't have any idea that there's a new system. Like, look at when they created the Sediki Act. Everybody did not know that they got transferred into the trading companies, into East Indian Company, Hudson's Bay Company. There was that other one.
Virginia. Was it?
Yeah, I think they made like 3 or 5 different trading companies in total. And when we actually understand the law of domicile and how this uses and trust actually works, we actually see that they use the trading companies to transport their law around the globe to get the inhabitants of these new lands to get an agreement to give them their lands for pouch tobacco. Now all the fee simple hold the lands as a use, and the king actually owns it. Then these indigenous people that used to own the lands that sold them to these people now have no more lands, so now they have to buy lands back from these people when they don't know that all they had to do is go to the court to take them back. Because by these indigenous people going and buying those lands from those people that only have a use, guess what? That's the same thing as that car that I gave you the right to. So those indigenous people gave me their lands for a pouch of tobacco. Then they buy them back for a ridiculous amount of money, and then they take on the capacity as being the trustee to that land now, because they had the natural right just to go to the judge, right, and say, I want it back, because the judge is the king, right? And as the citizen, everything that I buy and bring into the group is the king's. So if I got something from an indigenous person and that indigenous person wants it back in their true capacity, they have to get it from the court, right? So they would give me notice that, hey, I'm standing right. I'm now talking as the indigenous person, right? Give notice to the fee simple. You're holding lands in trust for me. I require them back. It's my true right and inheritance. When they don't do that, you make a claim to the court, and you make the courts give you the land, right? Because you agreed to the common law, right? And all equity follows it, that those in reversion and remainder supersede your rights, and that's their true inheritance. Because otherwise, the judge and all these fee simple are basically disinheriting themselves. They're removing their own natural rights. So if the judge is actually going to try to sit in front of you and tell you that there is no warranty, there's no such thing as natural law, and your rights aren't attached to the lands and everything else, he's a fucking liar. And you can tell him that right flat out. And that you're going to disinherit yourself and the rest of the world and destroy the interaction between men? Because we got to remember, law and agreements is the interaction between men. And if they break the interaction between men, all we have is war, because then they have no jurisdiction, because they have no agreement. So if there is no agreement, then that means that they're slave owners. So that means that doesn't work. So that's why Coke keeps going into the true inheritance and that being deforced and fulfillment and decisor and decisee and all these other terms those are all the people that are acting as a use and capacity. And you'll notice that in this current situation that they created, the fulfillors, I should say the fulfillees, the ones that actually got you to join the group, is the government. So when they say fulfillee, they're talking about the government. The one that's decised, right? Decisor or the decisee, that's the ones that are in possession of the lands. So that's why we have to go after the government, and the monarchy actually have nothing to do with this, because our rights are attached to the land. So we have to claim lands, and whoever's in possession of those lands is who we make the claim against. So if it's a provincial park, then you'd go after the resources, the one that holds the title to parks in the English law jurisdiction. So it'd be the Attorney General of your province, Lieutenant Governor of that province, and the Natural Resources Minister for that thing, right? Because you'd send him notice, and he'd be like, go blow, right? So then you'd have an injury, and as you can see, because they granted freedom, they made the government and the monarchy actually have nothing to do with any of this, right? The only thing that the government has anything to do with is your deed of release, right? It's the individual that's holding your lands that you choose that would be the one that injures you if they don't give them up when you give them a proper notice. And that's why in the claim and the writ of entries are all to the tenant holding the lands, not the government.
So would our claim be against the Rothschilds then?
No, it would be whoever. Let's say you wanna. You pick lands, and then you go to land titles and find out who owns them.
Yeah.
Because land titles will tell you two things: whether it's a defeasible title, and a defeasible title is a title held in fee simple. An indefeasible title is somebody who's already claimed the lands out and have exempted them from the English law jurisdiction. Because you got to remember, own the lands.
Yeah.
So how can she can't even give you those lands? So the Queen's Bench judge doesn't actually give you the lands; they exempt them. So they changed that into an indefeasible title. So that's why it's required to show a land title search when you're doing this with your claim, and you also want to put that as a notice to admit, because you'd want to have that land title search and have that attached to your notice that you're giving to the tenant, so you can prove that yes, they are in fee simple, and you've got full notice that you have a defeasible title, and I'm claiming it as my true inheritance. So, and that also gives the right for the courts to say, yes, you have a defeasible title, right? And we all know a defeasible title is a defeatable title, right? It means it's a title that can be defeated, right? An indefeasible title is one that cannot be defeated. So if it's already been exempted, when you go and when you do your land title search, before you even send your notice, it'll say, indefeasible title. And you'll be like, okay, well, now I can't claim this. See, because now you found the seat of law for the individual that you're claiming against. That's why we always have to look at what is their residence and what is their capacity. Do they own it do they have their residency as a residence or as a domicile? Because everything that's in an indefeasible title will be their own domicile, and those people have their own common law of the land, and they're not bound by English law. So you can't go and take an English law into a court and say that they're bound by it because they didn't agree to it. See what I'm getting at? So now you see what I'm getting at? So it all depends on that deed of release, because let's say you as fee simple went and wanted lands from somebody that had an indefeasible title and was out of the English law jurisdiction. As soon as you go and purchase that property, you've now brought it into the English law jurisdiction. Right? So now you've removed those lands from the natural jurisdiction and brought them into the fee simple jurisdiction of use and trust and granted it to the monarchy and to the government to rape it and pillage it for the equity to keep filling the corporate coffers. Because you got to remember, this is really going to start to make sense when we actually really look at this equitable system in the corporations. Because the corporations, the government, is paying all these corporations and making these private jurisdictions so their own companies that they created, right? The people that we put into the people that the fee simple put into government are creating their own corporations and monopolizing the system themselves and giving them themselves their own authority. So, as you can see, they're just creating more systems to keep taking more away from the individuals. So they're making a different class of slaves. Right? And people are not catching on because they can only take the equity if you're going to dig the ground and cut trees and everything else. You have to do the injury. The fee simple have to go and grab these lands and put them into the equitable group to be raped, because they can't do it in the when we're in our natural capacity, because it's all out. It's all yours then, your own individuals for the area that you're on, right? And if I was beside one of you guys, well, my area is my own private area, right? And the things that we agree upon between us only has to do with us. They could never do anything about it, right? But that's because we're not the corporate person, right? It's that corporate person that is, right? It's now you're working as a corporate person, so everything that you buy as that person becomes part of the articles of incorporation for that corporation. Has anybody here actually had an actual corporation or anything?
I've registered one.
I mean, an actual incorporation where you've actually had to go to a lawyer and make your own bylaws and everything.
Oh no.
See, and I have. I actually gave it up 10 years ago when I actually got my first real true glimpse of this and started me on this path. So that part kind of helps, because every corporation has to write its own bylaws and everything else, and that's what creates its constitution. And the corporation writes it, not my employees. I write my bylaws and my constitution for my corporation to be the advertising and the gravy to having people wanting to come be my customers or might even work for me, right? Because the better rules that I make for the people that join my group, the more people are going to join my group. You kind of see what I'm getting at? So every company makes its own rules and regulations, but yet they're incorporated by the English law, so they have to make those rules or regulations within those regulations, right? Again, jurisdictions and so on and so forth. But I was really wanting to touch on the point on why there's constitutions and bylaws for the corporation and how us as citizens volunteer to it. Right, and how that happened. So,
I've got a quick question then. So, say if you have created a company, like a limited company or something within your own jurisdiction, is there anything you have to do extra for that, or is it still just as simple as releasing from your individual court person and returning from sea?
Okay, when we're talking about actual things, you got to remember, the first thing that we have to remember is in fee simple, you don't own it. The only thing that you own is the equitable interest you can make from it. So, the Canadian Ownership Determination Act, like for Canada, because the way that Canada wrote their bylaws and their constitution and stuff like that. For the group here, if you were to sell all your assets and even your RRSPs and everything else, there's a big accounting formula. You guys should actually check it out. It's called Canadian Ownership Determination Act, and there's also Canadian Ownership Determination Regulations, and also a forms. They're all on canlii.ca. That's CANLII.ca. And you can just type it in the search; it'll come up right away. And you'll notice that this is an accounting act, and all your RSPs and everything else, like all your equitable interests, all the fiat, because that's all you can take. That's all that is yours in fee simple. So if you had a whole bunch of properties and corporations and things like that, it would be best to get an accountant to go through that act, right? Because that act gives you all the accounting and everything else on how these things get transferred. Because you got to remember, your birth certificate is the acceptance, and that does all the accounting to be transferred over in reversion to your live record of birth, right? For your writ of waste. So, everything myself. Well, I don't have any assets anymore because I actually had to figure this out. From me, so I don't have any of this to worry about anymore. But I did have pretty much an corporation, over $1 million of assets, and so on and so forth. And if I was in that position again today and knew what I knew today, I would have sold it all. I would have got an accountant to go through that act and to determine what is the best way to use this equitable value and put it in the proper places in that, as it states in that act for the accounting. Because some things in that accounting will times by 4 and even. So if we actually went through it properly and looked at it and planned for what the agreement says, we could I'm assuming, because I haven't actually gone through it all and everything myself to this extent, because it's of really no interest to me because I have no assets. And stuff like that. So if you actually went through it, basically be like understanding your income tax and everything really well, so you knew how to get the best return. So you could sell all your assets and put them in the proper things. If RRSPs gave you the best return for when you were in reversion, that's where I would put it. So this way, when the judge does all the accounting and the settling of accounts and passing of the accounts in the writ of waste, for terminating your equitable agreement, right? Because your land trust agreement is both common law and equity. You've given the land, and then also you have an equitable interest in it because you're the owner and beneficiary, and they have to give you what was agreed because you granted it for a beneficial interest, right? You granted something of value for value in return, right? This is all. I'm sure you guys are all really familiar with these parts, right?
Yeah.
So. And that's where all this really comes down to, is in the proper capacity. So we could actually liquidate our assets and put them in the proper places. So when we do the writ of waste, right, we would be getting the best value for our use, you could say, right?
Yeah, like that, you know.
So after you've done that, if you find that it would be better to put it in a can and bury it, do it, right? And I would suggest, like when we step back and look at the whole process, we can see that every step from the release from the getting the deed of release, the return from sea, the writ of entry, the writ of waste, every single step. We can stop our opponents in full and have a summary judgment or a summary trial, right? So when we add the being able to estoppel our opponents and a summary judgment for each level, we can see that this can actually be done within a couple of month period by doing a proper claim, right? Because it only take you a couple of months from the time that you start your claim to the time that it's finished, because it does as long as you can push it through with the summary trial, right? Because he has to it's just a fact of law. It's you put it in, he goes and reads it all, and he makes his determination. Right?
Isn't it Coke that says that as well?
Yes, they all say it. They all say it. It's. I got that one in over thousands of books, even in current equity today. That's just the rule of law. If you can prove it by a fact of law, it's on a paper, and both people signed it and agreed to it. That's a summary trial.
So good skills to learn, and it is like your notices and the doctrine of notices. Then
that's right, and making sure that they're worded properly, and that you've gotten proof that they've received them, so by registered mail. And also the biggest thing is don't jump into this, because there's lots of levels to it. And,
no.
And
I'm gonna keep hold of my cards till I know what I'm doing, man.
Yeah. So if we actually look at this, we can actually plan. You don't have to send anything in whatsoever until you have everything ready, until you have all your notices written up and they're sitting in front of you. You even got your claim written up, right? You got your affidavits written up with your motions, right? Because everything's already laid out in front of us. It's already in law. It's already all this is already a fact of law.
Yeah. Well, basically, if to use the doctrine and the notice as a good advantage, if you basically get the books and that right, and then went to a notary and got the notary to witness it, and then right, and then when again you've actually got and done another notary, you've got two witnesses in law.
That's right. Yes.
So you've won already.
Pretty much, yeah. You're just waiting. You're just trying to get it pushed in front of a judge so he can swing his gavel and say, "Yes, I read this and I agree with you." Right? Because everybody in fee simple is bound by the judge. Nobody can release anything, right? Like if I came to you and wanted a piece of land from you, even if you wanted to in fee simple to give it to me, you can't. You have to go to the judge and he has to do it because it's not yours. Right. Same with the government. Same with the government. The government can't even give you a deed of release. It's not valid until both the government's deed seal is on it and the judge's seal.
So what I done is I got myself a book on drafting, how to draft an argument, how to draft a case, and an evidence book.
Actually, I think once you guys do a little bit more reading and kind of get a little bit more idea on the whole of it, I think you're gonna it's all just gonna fall into place right for itself.
It's nearly there for me now. It's just a matter of getting the right documents and doctrines in place now. I get how it's working and how it puzzles together, and like you said before, if you were gonna melt everything down now and to get the best out of it before you went back and dismissed the corporate person, so you were looking after all the work that you'd already put in. If you wouldn't have lost yours, I think the only way to go would not be into any fiat currency or any situation like that. Maybe something like minerals.
Oh no, that actually doesn't have anything. That's what I was trying to. I was noticing that you were kind of off on this a little bit. So you got to remember that the reason why the assumption is standing for everybody to be the corporate person is because of what they're doing, right? So
right.
Let's look at the writ of entry. In order for a judge to accept a writ of entry, so decision in the post as you as donor, you have to prove certain things. You have to prove that you've already got a deed of release, that you've returned from sea, and that you're actually being deforced from your lands. So that means that if you're holding lands as an owner in fee simple, you can't claim a deed of release.
No, yeah, because you're still in D, aren't you?
Well, no, isn't that the acceptance? Remember what acceptance?
Yeah.
Acceptance is library by cession. So that's working as a corporate person, right? And being seized of your lands and living as in a residence somewhere and being the owner of it. Now, if we look at the treatise of landlord and tenant, I actually just posted this on Omnipotence for everybody last night, so it's the newest book posted.
Nice.
Please download it, because this is going to give you the summary trial for being deforced for your writ of entry.
Right.
If you are a tenant, like as in if you're staying someplace and you're paying rent to somebody, you are a tenant.
Right.
And the owner is the owner of the possession of the lands and of the fee. So you have to, in order to be divorced, you have to show that you're seized of your lands, right? So you're seized of the ownership, of the possession, and the fee. So by you being a tenant on lands and claiming reversion proves without a trial that you have been deforced. I think it's like on page 10. Like it's at the very beginning of this book.
Right.
And that's what we're, and this is what I was trying to explain, that we have to make the case. We have to make our actions comply with what the capacities in law are stating. So they can't say, no, you're saying that you want out, but yet you're working for co-op and you live at this address. So you're accepting what you're denying at the same time. So which one is he going to take? Is he going to take your words or your actions?
He's going to take your actions because they're louder than your words.
Exactly. So that's what I'm trying to really push to everybody, that we have to look at what the law says for what acceptance for that. What are we doing to, if we stop doing that thing, there's no longer the acceptance. And when we, with a fact of law that we're not doing that thing, and you don't have acceptance, because that's what everybody's doing. Everybody's going in there and saying, you don't have this right, but then they don't know the actions that they're doing is actually saying that they want that thing. Okay? The words that are coming out of their mouths is, I don't want to be a part of this, but then everything that they're doing is saying, I want to be a part of it. Right? So we have to realize, it's that actually tells us, it's the agreement that tells us who and what is in what capacity. So if you don't want to be that corporate person, you can't be acting as the corporate person. That makes sense, right?
Yeah, it does, yeah. Could we not just say we have a person and separate it that way? Do you see what I'm saying? Like, just say, yeah, I have a person, but that person is not me. Everyone's got a person. You need a person, don't you?
I kind of see where you're getting from with that, but the problem
is that not a separation in itself?
Well, it is, but it isn't, because
it's not enough to stand on. Is how I'd answer it back, like myself.
Because the person is more going on to the assumptions of the freeman on the land thing with the name, right? That jurisdiction is a name, right? So if we actually understand that it's actually a land tenure agreement, right? And that's why everything that I'm finding, if you're going to be in front of a provincial, like in an equitable court, provincial, federal, being charged with a government crime or something like that, they say that the individual has to make a claim to that chancery jurisdiction, because that's equity, right?
Yeah.
That against the fulfior and the decisor. So that would be against the government and the one holding your lands.
Yeah.
See what I'm getting at? So everything always keeps going back to the true subject matter, and that's you want the lands back.
once you put that in as well, that's into the higher court anyway. If you made that affidavit for that to happen. It should just
okay. Yes, I should actually. I kind of assumed, but that everybody always realizes that about 6.and chapter 18, affidavits. Affidavits are the main way of putting things into the court of record, and
right.
It's the main way of moving the court. So everything that you are doing is going to be done based on the 6.and chapter 18.
Yes.
So the judges, so you're being called into the court, right? They're making a claim against you. They think you're the corporate person. So you go in, you're saying, I would like to be the last person, and I would like the courtroom to be cleared because of what I'm going to be discussing could injure, right? It's a privity of estate, and it could injure my guardians, which are the fee simple, right?
Yeah.
By stating that is already telling the judge, right, that you already understand that it's about a land tenure, right, and that everybody in the courtroom doesn't have the authority to hear it, and if they did, it would actually hurt them because it would continue bringing more freeman bullshit and everything else.
Yeah.
Right, because they're going to take it in a complete wrong way. Right? They're going to assume all this other stuff, right? So it's going to injure and make things worse. So he's all of a sudden right away, boom. And then if he's going to give you any hassle, then you tell him, okay, well, here, I'm submitting you this affidavit. And you hand him that affidavit, and you put everything in that affidavit, 6.and chapter 18, including about the release and your lands and everything else, and make your claim right in that affidavit. And now he has to move it to the Queen's Bench court, or throw that claim out. Right, and he can throw the claim out, which he will, because he's not going to, which he probably won't move it to the Queen's Bench, and that's fine, because we have to go to the Queen's Bench anyway to make the claim to get them to stop.
You just do it to the judiciary then.
Yeah, because you got to remember the Queen's Bench regulates and restricts all lower courts and keeps them in their proper jurisdictions.
Yeah.
So they're trying to force us to be the corporate person and being gone to sea when we're actually alive and standing here on land.
Yeah, I got it.
On our own land, right? Because you gotta remember, common law is their law too. It has nothing to do with the donor.
It breaches equity as well because it's a corp against a corp. You can't have a man against a. You couldn't have the donor against the corp either.
That's
so it'd be breach of maxim.
That's in the de facto doctrine, because a de facto only has the authority over its own subjects.
Yeah.
So that's also on omnipotence as well, and that's really good to have. The judges hate it when I do that. So
decent, man, decent.
So yeah, once we actually start really getting down to the real true defining determining factors of what the foundation documents are about, they lose all authority, right? And all we have to learn to fix this is jurisdiction and finding the seat in law for everyone and everything that we're trying to claim against or to claim authority over, right? So if you're claiming land, you got to prove that you have the authority to do it for yourself, right? And that the person that you're taking it from, and that you can actually take the lands, right? That's why I said you actually have to go to land titles and make sure that, right? Because the domicile, right, your lands determines your jurisdiction, right? You see what I'm getting at? And it's your capacity that you hold those lands that determines your jurisdiction. See, so jurisdiction just keeps falling line up. Everything deals in law with the jurisdiction. If you cannot find the jurisdiction that's the acceptance to it, and the law that and the actual agreement, there isn't any. Right? And when we actually start standing there as a donor, because you got to remember, by you being fee simple in English law, when you accept something, you ratified all the past wrongs of that group or that jurisdiction. So you're accepting all the wrongs to it. And that's why English law is actually unlawful, but it's legal, right? So that also brings us to like Canada, the UK, United States, all these English law municipal government corporations are all de facto. You see what I'm getting at? But they're not de facto because everybody's agreed to accept them as being law. So that makes them legal, but they can never be lawful. Right? Because there's always somebody else that's going to be in their true capacity somewhere, so it's going to be unlawful. So as soon as you no longer have that acceptance, all these things now become de facto and unlawful. But, right, because we got to remember that your capacity and your jurisdiction determines if it's right or wrong or not. And it also depends on who's it's to and everything else, right? Because fee simple to fee simple, it's all legal and it's all fine, right? But when you're talking about donor and fee simple, nothing is lawful anymore. Everything is not only unlawful, it's illegal.
Right.
So, yeah, it's basically just proving to everybody that all law since 1066 still applies. You know what I'm getting at? But it depends on your capacity in law. If you're a citizen, then only the law from 1925 till today applies because you've joined the Land Trust Company. And the Law of Property 1925 created all the governments and made them into land trust companies and made all the individuals fee simple absolute. And then we'll start getting into the actual acts and statutes to prove that these citizens that are in fee simple have to do these things when we give notice and everything else. I already have all the laws for Canada, for the law of conveyancing, law of property, law of real property, Landlord and Tenant Act, Commercials Tenancies Act. It's all in there. We just have to start looking for the right words and the right terms and being used in the right fashion.
Decent.
So,
I'm getting a picture of it me now. It took a few months, but it's getting there. And I'm gonna read over Maitland's work and Coates and Blackstone again as well.
And just remember each chapter.
In a minute.
Yeah. Each chapter though that you read, it talks about capacity that could be possible in that area of law. So Some chapters could be talking about 20 different capacities and 20 different jurisdictions. So you have to be able to pick out which one is for you. See what I'm getting at? So that's why when you see fulfillment, decisor, decisee, donor, donee, future interest, right?
Right.
Reversion, remainder, those are the key words they're actually talking about the land trust.
Yeah.
Right? So, because that's a lot of people get confused by reading the law books, and that's the problem is there's so many capacities that they're describing in that chapter because that chapter is about as cheats. Well, they have to talk about all the different ways that cheats work to all the different people in that jurisdiction, right? They can't leave anything out, otherwise there's no information for anybody. So they just keep throwing it all into a box, every type of area of law into a box, and they just throw it all in there to confuse you.
And it fucking worked.
Fuck, did it ever? I swear I've read over 1,000 law books, like well over 1,000 law books, most of them over 1,500 pages. And I read them page by, like, not missing a single page to get all of this. Like, it's been ridiculous because, like, I started like with the Freeman type of thing, right? Like Dean Clifford and all of that. Like, I know Dean Clifford.
Lunch at any time.
You know, and I was free Manitoba and all that stuff. So,
what do you think of Carl Lentz? The story goes like he beat Queen's Bench and the judge shook his hand.
I haven't really looked much into Carl Lentz. Last time I looked into it, he was still he's still trying to get the equitable remedy, and he's not trying to get absolute freedom. Where
Right,
I've never looked for an equitable remedy. I didn't want equitable freedom. I want true freedom.
Yeah.
Right? And
Different
I've never ever looked into even the accepted for value and stuff. I have looked into it, but I've never put any amount of time in it. I've never tried to do any of those things.
I'm not feeling the acceptance for value thing. I think it's anything to do with the money coming that easy's got to be wrong, hasn't it? I was taught that as a young child, really. Anything that seems too good to be true normally is the saying, isn't it? So you're just writing things off all the time.